Hey, good afternoon and welcome to the June 18th, 2019 Board of Selectmen meeting. One item on the agenda this afternoon is a discussion on recreational marijuana sales and host community agreements. And Jeff, I will turn it over to you.
Thank you, Madam Chair. This evening we have Jean Boubon and Nicole from the town council's office, I guess we call them in Massachusetts.
Yes.
And they're going to walk us, or Nicole will, talk about the legalities of the host community agreement, their purpose, kind of what should be in them, what to look for. And then Jean's going to give a brief synopsis of the packet you have in front of you, which is kind of a detail on all four of the proposed retailers. So with that being said, I'll turn it over to Nicole.
Good evening, afternoon.
Hello, everyone. So my name is Nicole Costanzo. I'm with KP Law Town Council's office. And host community agreements, there's really no one size fits all for these types of agreements. They vary from community to community depending on the concerns that are raised by the residents and by board members. They also depend quite a bit on what type of establishment is being proposed. As you know, the licenses that the Cannabis Control Commission issues, the State Licensing Commission, range from retail, cultivation, manufacturing, processing, and a combination of some of those. So the host community agreements that we see do vary, again, depending on the type of establishment that's being proposed. For example, if there's a cultivation facility, and it's indoor versus outdoor, there might be concerns about odor, waste management, lighting. For retail establishments, such as the ones that have been proposed to the town, a lot of concerns that we see deal with parking, traffic control, hours of operation, design, review and limitations on sizes, appearances on structures. It depends if there is an existing structure that they're going into, if they're building a new structure. Limitations on or prohibitions on sale of on-site social consumption and home delivery. Again, there's also some signage limitations that we've seen go into these host community agreements. Limitations on products sold. While it's uncommon, we have seen some host community agreements that do limit the types of products that can be sold at retail establishments. In addition to those, we've seen a lot of host community agreements include what's called a community impact fee. Now, a community impact fee is something that is regulated by statute, and the law provides up to a 3% community impact fee, and that's 3% of the gross sales at the establishment, gross annual sales at the establishment. And the law provides that the community impact fee provision of a host community agreement could be for no more than a term of 5 years. Now, that can be subject to renegotiation, and the host community itself could be for the life of the establishment, with the limitation on the 5-year terms for the community impact fee. We've seen the community impact fee structured as a percentage. We've seen it structured as a specific amount. Some communities have done annual payments of the host community, of the community impact fee. Some have done quarterly. Some have based it on a calendar year, and some have based it on a fiscal year. Again, it varies from community to community. In addition to that 3% community impact fee, some municipalities have asked for a community benefit fee, which is not subject to any monetary regulation by statute or by regulation. And the CCC, the Cannabis Control Commission, has already stated that it will not be regulating the host community agreements. And so it is an agreement that's subject to negotiation between the applicant and the municipality. We've also seen in there benefit payments for local charities, for police education for enforcement, for example, training to see if someone is impaired or under the influence, specifically for marijuana. In addition, some other drug enforcement costs we've seen are host community agreements provide payments so that schools can get a drug education officer come in. Some host community agreements have timelines for opening, and I could talk a little bit more about this in communities that specifically have a limitation on the number of retail establishments that can come in and locate, which Sturbridge does. We've also seen a lot of host community agreements have requirements that the applicants work with the local police department and fire departments for traffic and for security provisions and plans. And so, again, there's no one size fits all. It depends what the town believes that it needs. And these host community agreements are to be negotiated with the applicants. Some host community agreements also include a number of hours that the applicant has pledged to volunteer themselves to participate in health education or in public outreach to explain to the community the benefits of their establishment and the health implications associated with the products that they are selling. We've also seen some host community agreements having reopener clauses. These are used when there is an applicant that has or that anticipates on having more than one establishment. And the reopener clause would allow the town to reopen the host community agreement if the applicant opens another facility in another community and executes a host community with more beneficial terms. So for example, if the town didn't anticipate, that they would like to have a drug recognition expert training program for their police and it was offered in another community, they would have the opportunity to go back to reopen the host community agreement and negotiate for that. Most host community agreements that we review, we typically include, if they're not already in them, some standard provisions, indemnification and hold harmless language with respect to any claims arising from the permitting of the establishment. We also include provisions to address assignment, sublet, transfer of rights and obligations under the agreements, a commitment not to challenge the terms of the host community agreement or the legality of the agreement because this is a brand new area of law and there isn't much guidance out there. Some communities have required annual inspections in their host community agreements and annual reporting on compliance because some communities choose to negotiate for a community impact payment that's based on a percentage of gross sales. They've asked the applicants to bear the burden to report those gross sales and also to have an auditor review those in case the town believes there is a discrepancy. Some host community agreements also address odor control. We see those more from manufacturing and cultivation establishments. Again, I mentioned waste and water controls and electrical usage. We also recommend that communities request a provision that the applicant not challenge or appeal building permit application fees and local charges. And in addition, we've seen a lot of applicants actually offer to include local hiring preferences in their host community agreements, to say that they would give a preference to town residents and also to local vendors and contractors if they are building a new establishment. Now, before I touched a little bit on this limitation that the town of Sturbridge has on the amount of retailers that can come and site in town, I don't believe the town has established any specific screening criteria or developed a policy on how to determine when that limitation becomes set in stone. Is it that the host community agreement, once the host community agreement is issued, the town has reached that limitation? Is it when the applicant receives a special permit, or when the applicant receives the final license from the Cannabis Control Commission? Again, there is no right or wrong way to do this. We've seen communities done it in a whole variety of ways. Some communities have said we have a limitation. For example, we have a limitation of 4 retail establishments that can site in town, so we are only going to enter into 4 host community agreements. Again, they put some time frame on those agreements as to when the applicant has to obtain their final license, and if that time frame passes, then the host community agreement becomes void and they can go look to enter into another host community agreement. Other communities have said, well, we don't know if the applicant is serious. They can be they can be executing a host community agreement, but there can be issues that relate to finances, or for other reasons, they find a different location and choose not to site in town, and therefore we don't want to limit ourselves. So some communities have decided to enter into as many host community agreements as applicants come forward, and then have decided it's the first business that opens its doors, or it's the first business that gets the special permit, or it's the first business that gets its license that counts for the number of retail establishments that are limited by the town's bylaw. We've seen it done in a variety of ways. I would recommend that the board does adopt a policy as to how you will be implementing that limitation. If the board decides to limit the amount of host community agreements that it enters into, I would highly recommend that the board request that those applications have a sunset provision, meaning an amount of time for the applicant to obtain its license from the Cannabis Control Commission. And of course, that could be extended for good faith reasons if there's a holdup with the state and not that the applicant is just sitting on its rights. Some other screening criteria that we've seen are knowledge and understanding of licensing, prior cannabis experience, the quality of the business plan, the proposed development timeline that an applicant is submitting, the potential for job creation based on the size and scope of the operations, community connection and local residency, again, parking and traffic management, financial commitments to ensure that, or to help ensure that a applicant is actually going to open in accordance with the timeline that has been proposed, geographic diversity, and also opportunity for woman-owned or minority-owned businesses. And those are just some of the criteria that the board can consider. I don't know if the board has any specific questions or if Jean wants to add anything.
No, I think you covered it.
Any questions from the board? Mary?
I don't want to go, usually start at the left.
Well, I know,
Are you
but your-
sure, okay?
Your
Okay.
hand was.
Okay, I have quite a few questions, so I just.
It's a lot.
No, you said a lot, yes, thank you. In terms of, I'm still having a little difficulty understanding the process of, when you said we don't have a policy on limitations, how many host agreements we're willing to entertain, and at what point in the process, permit or final license. So I get that. So we do have, 4 interested businesses for 2 permits, or 2 licenses, depending how you want to look at it. Are we free to negotiate with all of them and make a decision based upon which business is willing to enter into a host agreement that we deem is most advantageous to Sturbridge? Or do we have to decide on the 2 and then enter into negotiations with them? Because I'm feeling like it would be preferable from the town's perspective to be able to do the former. Let's say we had, I'll just throw something out there. I don't know how the rest of the board feels, but I personally think traffic will be an issue, particularly in Sturbridge, because unlike other small towns, we have access to 2 major highways. So I anticipate, people coming in, as I'm sure that's why we're a desirable place, because it's going to be profitable for them. And so let's say we wanted to have by appointment only, to limit the traffic, and so that, they're not seeing 1,000 customers a day, 5 days a week, and basically shut down the town. Are we free to negotiate with all of them and see what their position is with respect to that type of criterion? Or do we have to move forward with 2 and then negotiate? That's my first question, and then I have a few more, but maybe you addressed it, but I just didn't totally grasp it.
Sure. So again, there's no set way to do this. The board can look at all of the applicants. They can consider everything that's being offered. One of the things that you mentioned that you can consider is traffic. And
Right.
if there's this, it's the app that they're using for delivery only.
Right.
If certain applicants have that and the town thinks that that's beneficial to mitigate traffic and parking concerns, that's definitely something that the town can consider. And the town can seek to negotiate host community agreements that would include those, and then decide based on those discussions with applicants which host community agreements it's going to execute. The town can also execute a number of host community agreements, and then if a policy has been adopted, and then say, well, it's the first one to get the special permit from, the first one to get the license from the CCC. It's however you decide to do it.
Okay,
But
so
yes, you can.
So we can negotiate with all 4 right now prior to making any kind of decision as to which 2 are going to get their go-ahead, I guess, from the board.
Jeff?
We would recommend that.
Yes, no, I would.
Prefer that.
I would prefer that as well, but I wasn't sure how that, and then I had a question too on, I know you said that you're recommending within the contracts a commitment not to challenge the host agreement in court, I assume. So would preclude them from, like, I know right now with contracts, you could move forward and say, this is void as against public policy, and sometimes the court will strike down a provision in a contract. So they're agreeing up front to not challenge, but does that preclude their right to challenge that provision? I guess because it's a new area of the law, I think we're going to probably see that.
So we would argue yes, but because, as you pointed out, it is a new area of law, there aren't many cases on this,
Right.
and so we have no precedent set forward, but it's an added layer of protection in our opinion.
Okay, and then another question I had, I know that we can negotiate up to 3% of a community impact, which is governed by statute, in terms we have to show that there will be an impact. But then you talked about the community benefit fee. So now, my question is, can that also be like a percentage of their profits? For example, if we determine that traffic is going to be pretty onerous and it's going to contribute to a lot of negative impact for our town, could we say that, I don't know, a certain percentage of their profits gets put into like an escrow to help us come up with a plan to alleviate traffic? Can they build on that every year, even if we don't use the money in that first year to do something? Because we'd like to redo Route 20, for example, and alleviate our traffic, which is getting worse and worse. with ways, redirecting through Sturbridge. It's affecting our small-town character. So could we say a certain percentage every year has to go into an escrow for a future project? Or do we have to use that money that particular year?
So, to separate it out, the community impact fee is meant to reimburse the town from impacts foreseen and right now unforeseen, because we don't have any clear, again, precedent, and the establishments haven't opened yet, on the impacts that the town sees due to the establishments being located in town. So, for example, if there's more usage to roads and we need to do more road work, or we need police details, that would be something that the community impact payment is envisioned to reimburse the town for. The community benefit payment can be structured in any way. It could be a percentage of gross sales. It could be a set amount each year. It could be a quarterly amount. It could be an amount every 3 years. Again, these host community agreements are to be negotiated between the town and the applicants. So it really all does depend. But the community benefit payment would not have to be allocated to a specific purpose. So the community impact fee, the town will have to document the costs to establish that there are community impacts, that the community impact fee is being used to cover. The community benefit payment, there isn't that requirement.
Okay, because it's not overseen by the statute. Is that why? I mean, it's not going to be reviewed by the Control Commission.
And neither is the community impact payment, but under the statute, in order for the town to continuously be requesting a community impact fee, it has to be proportionate to the impacts that the town is actually facing.
So we have to have some evidence to establish that, for example, we have a right to the maximum of 3, but we don't have that proof requirement for the benefit fee.
Correct. And the way that we've structured a lot of these host community agreements is to put in a provision to say, you haven't opened, these are brand new, there are anticipated and unanticipated impacts, and we put in provisions that the applicants don't challenge the community impact fee, and again, it's subject to negotiations, but that's language we would recommend, because for the first year of operations, it would really be difficult for the town right away to determine what the impacts would be.
Okay. And then, I'm sorry, I don't mean to, I still have another question, then I'll turn it over. You talked about some typical requirements in a host agreement when they have retail shops, and one of them you said is a limitation on the types of goods sold, and you said that that's not typical, but they are in some. Can you, without, violating any kind of attorney-client privilege or anything, tell me what communities put a limit on those, and what kind of, give me an example of what they did.
So I don't have a list of communities off the top of my head that have done that. Some communities have restricted the types of products that can be sold at the retail establishments. It depends the scale of these. Most of them, I presume, are going to be selling edibles, lotions, tinctures. It all depends. And again, I just want to say none of these are requirements, because the host community agreement is a negotiated agreement. These are just provisions that we ask applicants to agree to.
Okay, and some towns require no on-site consumption? Because you said that there's
yes, I
on-site.
believe Sturbridge has a bylaw
we
that
do,
also
right. Okay,
covers that.
all right.
But for example, I think that the medical marijuana host community agreement that the town entered into had some limitations on the edibles.
Correct.
Mm-hmm.
Yeah.
Okay, thanks.
Okay, Priscilla?
My question is about if we have a host agreement with a medical marijuana facility that we allowed to go to retail in 5 years, because at the time we entered into the agreement, marijuana wasn't officially legal yet. It hadn't been voted in. Can we renegotiate that contract now and allow them, since the law is legal, allow them to start retail now.
Sure, medical marijuana was legal, it wasn't recreational.
Right, it's
Just-
recreational I'm sorry, I didn't state it correctly. You're right. It was the recreational piece, because the medical we approved without any issue. But the component to it was that in 5 years, because it was anticipated the law was going to go, that in 5 years, they would be able to do retail, commercial,
Retail
type.
yes.
So now it happened quicker than we thought at the time. And so now can we go back to them and open it up with them and say, yeah, you know what? Yes, you can do it now if you want to.
So the agreement that the town entered into allows for amendments by agreement of both parties. So if the applicant agrees to open up and renegotiate, which I assume they would like to do,
They would, yeah.
and the town is agreeable to that, I believe it's within your authority to do.
Okay, great, thank you.
That's it.
Yeah, that was easy.
I mean, we could waive any requirement if we wanted to, that was there for the benefit of us, right? I mean, it's just like any other contract.
So to waive a requirement,
Well, I mean, it's
the
the
town
same
could
thing.
choose.
I mean, we could amend it, but it's very similar in regular contracts.
The town can choose not to enforce a provision, but in order to actually amend the agreement, there would need to be, yes.
Renegotiations.
Case?
Is there any, this is more a question for our town administrator, I guess. Is there any way we could get, when we're negotiating, a copy of the CCC regulations, the Cannabis Commission regulations?
Sure.
You can easily get them online.
Yeah, we can get those.
Thank you.
Yeah, and going along with that, because you do recommend, and it's kind of obvious that we should have a policy on limitations, how many we're going to negotiate with, and, have a sunset clause and all of that. Could you share with us some examples, without the names of the towns, but just some of the types of provisions that towns have had, so I can look at them and kind of see which ones I think are stronger than others in terms of what they have for a policy, so we're not reinventing the wheel, in other words.
Sure, so some communities have actually
I know the language.
imposed a local licensing requirement, which is allowed, and there's a licensing process. And some of the screening criteria that I mentioned earlier is part of their license application. Some communities have established some application requirements for the board to consider entering a host community agreement, and again, some of those screening criteria are there. Other communities have issued RFPs and treated this as any other bid.
I get it. No, I'm following you, but what I'm asking for is the actual negotiated, actual language of the policy, like the boilerplate language that's used, rather than us trying to go from scratch. Because I know a lot of communities are further along than we are, and they've done their homework too. So I'd like to see the language, the policy that they came up with. That's what I'm asking for.
Sure, I don't know if there's boilerplate policy language,
Well, not
but I can, yeah,
boilerplate,
I can
but
go back and.
You know when you're saying some communities
Yes.
have done this, some communities have done that, I would like to actually see the document itself
Sure, I can go back and see if we could pull some and send those
as
along.
examples, so that we have something to work off of, if you will,
Yeah.
rather than trying to like divide our own language from scratch. That would be helpful for me, actually.
Sure.
Well, I think for all of us.
Yeah.
I mean, we
Yeah,
don't want to reinvent the
everybody
wheel,
wants to see that.
Yeah.
you know.
Madam Chair?
Priscilla?
In line with that, can you send us a copy of some type of an idea of a policy that some communities, you can eliminate the community, but give us a handle as to what some of the things are that they restricted or allowed or whatever. Doesn't mean we'll follow that, but at least it gives us an idea where to go.
I totally agree. That's actually what I was trying to get at too,
Sure, so some.
We can compare and contrast a little bit.
Some common provisions
Yeah.
that we see in host
Correct.
community agreements.
Even if it's
Sure.
just the provisions, right, exactly, just so that when we sit here to discuss this, we don't have to like try to reinvent the wheel?
I do believe that we did send a draft proposal for some template host community, for a template host community agreement with some language that we do typically recommend, and I
You
think
did,
that
but
was
it
part of
wasn't,
your-
it wasn't as
Well, Jean,
specific as, go ahead. No, that's
there
it.
was one in the packet.
There was one in the packet, but,
This evening. No, I see what you mean. The more
Yeah.
examples we have, the better off we'll be making a decision.
and the more efficient, like, we could go a little quicker. Because there might be something in somebody else's host agreement that we actually didn't think of. And when we look at it, we might say, wow, that's excellent, that also pertains to Sturbridge, but we just didn't brainstorm and come up with it. And since, you know, you're our council and you represent a lot of towns, that's one of the advantages of having council that represents towns, is that you can assist in this way.
Okay, any other questions? My questions have been answered. I know it's not a public hearing, but do any of the proponents have questions they'd like to ask? Mr. George?
Yeah, thank you, Madam Chairman. I'm Bob George, attorney.
Hey, Bob, could you use it's for the audience at home.
Ms. Dowling, as to your question, if you check the package that we initially submitted to you, there's a complete host agreement in there with all the things I think.
saw that, yes.
Oh, okay,
Thank
that
you.
might help you out. And the only other question is for Nicole. On the impact fee, is it specifically used only for documented uses, or can that be accumulated or used to, you know, knock the tax rate down or things like that? Is it exclusively used for that purpose?
So there is a sales tax, a local sales tax that has been adopted by the town, and the community impact fee would not offset that.
Well, let's say there was no impact to the community. Would that fund become accumulative?
I'm not sure I understand your question if there were no impacts to the community, but I think the questions that you're starting to go down would require negotiations for a specific host community agreement, and I don't know if the board would like to entertain that right now.
I'm just curious as to how the fund would be used.
So it would be a community impact payment, and the 3% of the gross annual sales, or whatever the board decides through negotiations would be, that money would be used to offset the course, would offset the impact. So for example, if there were police details and overtime payments for those, that the community impact payments would be used to offset that. If there were damage to the roads because of the increased use from customers coming in, the impact fee payment would be used to reimburse that. If there were questions and enforcement issues and legal counsel was needed, the community impact payment would be used to reimburse those types of costs.
Okay, and just for the benefit of the community, supposing the funds were not used for any of the purposes you said, and let's say, for an example, $100,000 was submitted to the town, only $80,000 was used for what you said. What happens to the other $20,000? Can the town use it to offset the tax rate or buy a police car or something like that?
So the money from the community impact fee would be put into the general fund,
Fund,
and it would
okay.
then be, it
That's my
would then have to be
question. Okay.
appropriated.
Thank you.
We
Mary?
find a way to use it.
I can't.
We have a lot of needs. If we don't, we'll find them. Mary, you had another?
Yeah, no, I still want to go back to this community benefit fee, because when researching on my own, I know there were a number of advocates for the, not for the town, for the industry side, saying some of what is being agreed to seems pretty outrageous. I mean, that's their term, not mine, because we represent the town. But can you give us some examples of communities that have gotten a benefit that is very, let's say, generous for the town? I mean, they gave some examples, and it certainly looked like there's going to be litigation saying, like, look, this is a little bit ridiculous. But yet the businesses has been agreed to it in the host agreement. But give us some like concrete examples in Massachusetts of what kind of benefits have accrued to the town. And I'm talking about the benefit now, not the,
Community impact.
not that's pretty clear and straightforward, that has to be a negative impact. But I'm talking about the benefit, because some of what I saw seemed extremely generous, and I'm wondering if you can, even for the people watching, like, give us some concrete examples. I know no one side fits all, and I get that, but could you share with us some examples of some of the things that towns have benefited from?
Sure. So I don't, again, off the top of my head, have a list of any specific communities, but we've seen community benefit payments as another percentage of gross annual sales. So an additional 1%, an additional 2%. We've also seen some communities that have just asked for a specific dollar amount. For 50,000, 100,000. Again, these all depend on the size and scale of the establishment. And I really do want to emphasize there is no one size fits all of this, because if you're having a smaller retail establishment versus a Costco of a retail establishment, there's going to be different impacts. And so the host community agreement is meant to be tailored to the specific establishment and
I
to
get
the
it.
community
What other,
needs.
like, projects, though, other than
so-
monetary allotment?
So we've seen a community benefit payment structured so that it does apply specifically for drug enforcement costs. So we've seen a community that wanted to hire almost something like a DARE officer to come in to talk to students about drugs and to educate them. We've also seen, like I mentioned before, the community benefit payment specifically proposed to be used for drug recognition training for police departments.
Yeah, these are all kind of
So,
like
and
typical.
those-
Yeah,
but
yeah,
those-
I'm
those
talking about the
are-
more, I'm talking about, like, have you seen them give money to a project for a town, or, so, because these are not gonna, these are the kind of things
We've
that they
seen
never
them-
challenge. These
sure.
are like natural.
We've seen,
That's what I'm
I
asking.
believe there was a community, a host community agreement that provided for a new police cruiser. I know we had one community that had concerns about having overdoses, and so they were proposing asking the applicants for a benefit payments to have an additional EMT officer, an additional training. So again,
On a regular basis, so they funded an additional position within the fire department.
so it was an amount to cover that as the community benefit payments.
On an annual basis.
On an annual basis
For
for
the
this,
term of the host
for,
agreement.
for this community, it could be limited. Again, it could be for the first 3 years of operation. It is a negotiated agreement, so yeah, the terms could be as expansive as the parties negotiate for. But yes, it could be annual. It could be for the life of the operations. It could be for the first 3 years of the operations if the community feels, listen, after 3 years, we're not going to have that many impacts. If the community feels that there have been other stores out there in other states that still see impacts today that have had these establishments for more than 1 year, they could do it for a longer term.
But you've seen applicants fund positions within the safety area of towns. That's my,
I've seen communities negotiate for that.
well,
Yeah.
okay, yes, thank you.
Yeah.
Okay.
Yes.
And again, some host community agreements will explicitly say it in there. Some will just include a dollar amount, and the dollar amount is used for that.
These are all seem very, very straightforward. I've actually seen examples that, and I don't know if you represent those towns, that are a lot more lavish, and I just questioned if you had knowledge of those, but
I mean,
maybe you can look into it a little bit for us, and I don't want to put you on the spot tonight, but I just want to have a better sense of the parameters of what we could request to benefit the town.
well, so Again, I don't think there are really
I know
any
we negotiated.
parameter- yeah.
I understand that, but other towns have already,
Depends on what's negotiated, what we're asking for and what they're willing.
yeah, but.
And
right.
somewhere in the middle.
We can get whatever we want if they're willing,
Yeah.
you know.
Well, we don't want to scare these applicants either, you're running out of here.
That's why,
Sky's-
we're not the first town to do this, so I'm trying to just get
yeah.
examples. I know it's a negotiated agreement, just like all contracts, but my question was a little bit different.
Yes.
Thank you.
She wants
An example of,
a new building.
no, I just want to know what's
No, I know.
considered, reasonable and what isn't considered reasonable, and I know it's negotiated, I get that.
But it sets a spectrum too.
It's just,
Okay, so
that's
you're
all
right,
I'm
you
asking
know,
for.
right.
I mean, I know that they're negotiated, that's,
Anything is acceptable if someone's willing to do it.
That's
Well-
right,
The bottom line, right?
except the state.
Except the state.
Okay, does anyone else have a question, or? No? Jean, anything you want to say, or?
No, I think Jeff just wanted me to give an overview of the 4 sites and where we are as far as staff meeting with them. If you're done talking about those communities, then I can do that.
Yeah, I think,
Yeah, I think so.
please.
All right, so I did provide you all a brief packet. I know you all have volumes of material I've been sending over from all of the potential applicants. So just to summarize the 4 sites and companies. So the first one is 253 Pharmacy, and that's at 138 Main Street. The primary contact there is Seth Rutherford. He's the Director of Sales. The property there is zoned commercial, and that's the former Paletti's location. So 253 Pharmacy met with the land use staff on April 17th, and they provided an overview of their proposed business and operating plan, conceptual site plan at that time. And I did provide you with a copy of the report that we sent to them, detailing what we found as deficiencies or lacking information. And I just want to report that since that time, I've been working with Mr. Rutherford, and he's addressed all of those outstanding concerns. They've had a traffic study done. They've come a little further with their site plan. Obviously, we have to remember, we're in the conceptual phase. We don't expect anyone to spend all of their engineering funds not knowing if they're going to be an applicant that's moved forward through this process. But they have, I've sent over everything as they've dropped it off in our office. I think you have quite a bit of information from them to look through. And I've provided a map. I know that you all know where the location is, but I just gave you a map so that you can see it in relation to the surrounding buildings and what's around it. And again, I've included that letter again, the staff report. The next one is caregiver-patient connection. And they came to us originally with the 214 Charlton Road site, and you'll recall the chief had some serious concerns with traffic in that location, safety. So since that time, they have evaluated several other sites in the community, and they came in and met with the land use staff again on June 5th with a new location. They are now looking at 365 Main Street. Again, we found their presentation to be very thorough as far as their operation and management goes. The site is the former mobile gas station, so it was a site that was accustomed to having quite a bit of traffic. It has been closed for a few years now. So we gave them some recommendations to work on a traffic study, reach out to Mass DOT to see if a new access permit would be required. And the only real concern or issue to be addressed is there is the mobile home community directly behind that. Excuse me, thank you. So they are well aware of that, and they are working to develop a plan that will allow them to construct a building and operate there without impacting those residents. In fact, the latest communication I had with, the primary contact is Catherine Trifolo, and she's the president of Caregiver Patient Connection. That property is zoned commercial. And the latest communication that I've had with Ms. Trifolo is that they were signing an agreement for purchase and sale today. So they are, I guess, locking up the property for the potential use. And there's a conceptual site plan that was provided to you, and they are now going to reduce the size of the building so that it'll be less of an impact on the mobile home park. So I think that, they've done a really good job of addressing concerns. They did a really quick turnaround with a new site, and you'll see that the new letter, the new correspondence that's in there is dated June 6th, and it, again, only speaks to those two issues, the mobile home park and traffic, which would need to be addressed for any of these applicants going forward. The next one is Heal Incorporated at 660 Main Street. Our primary contact is Catherine Brocher Adams. She's their attorney, and she works for Schlesinger and Bookbinder, LLP. The property that they are located at is in the General Industrial District, and it's also in the Medical Marijuana Overlay District. So this is our one approved medical marijuana dispensary in the community. They met with staff on May 15th. We had no concerns with the site, as we had already vetted this location, the building, their processes. The only thing we would recommend is that they provide an additional updated traffic study if they were to convert, and that also they use the appointment-only app at startup of operations, which they have agreed that they would do. And again, I've provided a map. I think you all are familiar with that location. And the last one is the Herb Company at 55 Main Street. Our primary contact is Deb Crowley. She's the president of the company. This property is located in the commercial district, and it is the Fisk Hill Plaza, and they will be going into one of the vacant storefronts. We met with them on April 17th, and they provided an overview of their company and their proposals. They had very limited information for us at that time, and we found their proposal extremely deficient. However, since that time, we did send them correspondence dated April 24th, and we outlined all of the outstanding concerns that we noticed at that time. Since that time, they have brought into the office documentation to address all of those concerns. They have had a site plan prepared, they have done a traffic study, they have developed some of their policies, they have agreed to reduce their hours on Sundays, they have met with the neighbors, and they have had initial discussions with the chief of police. So they've done quite a bit of work in the meantime too, and I would say that they've basically addressed all the deficiencies we noted at that time. So those are the four that we have. We've spent a great deal of time with each applicant, tried our best to provide you with all the information that we're getting from them so that you can stay aware throughout this process. And we're just, from my standpoint, waiting for this board to make a decision as to the direction that we move forward so that I can work with Mr. Bridges to continue this process.
Okay, thank you. Any questions?
I have a couple.
Mary?
Of course. Well, it's only 6:20, so we're still in good shape. So the Herb Company.
Yes.
Initially deficient in terms of the information, but they have since, you are now since satisfied that they have addressed everything.
Yes,
Just want to
they've-
make sure I took the right note.
Yes, they've done quite a bit of work, and you should have a copy of their updated information as well.
And I apologize if it's in this packet to everybody here who are applicants, but what I did like about the Herb Company is that they said they wanted to be a good neighbor, and they actually reached out to Napoli's Pizzeria and the paint store and got letters indicating that they were favorable to having that tenancy.
Right.
So I think that is indicative of trying to be a good neighbor. Did the other applicants also do the same?
No, and I'll let you know why the Herb Company actually did that. Our concern from a staff standpoint was that was in a multi-tenant plaza with many other businesses.
I understand.
We were very concerned of them using parking that was needed by other businesses. When they came in initially, they had no traffic data at all, and they gave us very generic information. So
But the other applicants, I understand they're not in the same kind of a complex, they're going to be a
Right.
freestanding building, but they still will have neighbors.
Yes,
Did
they-
any of them reach out to the neighbors that they will have?
Well, so Heal has had a community meeting, and nobody attended that meeting. The others have not held a community meeting. The 138 Main is a standalone facility, so just to finish what I was saying on 55 Main, we were very concerned that it was in a very busy plaza with many tenants, and that's why we had asked if they had reached out to any of their neighbors in that property, because it is a shared parking. The others, we weren't encouraging them to do any outreach at this point because they were standalone facilities. So once we know if we're moving forward with any of these, then they would start the community meeting process. It was,
Okay.
when we
No,
looked at.
I understand.
Yeah.
I guess I wouldn't have distinguished them as much. I understand what
Yeah.
you're saying, but in terms of like, even when you're freestanding and you got a business on this side and a business on this side, they're still utilizing the same road. I know
Right.
it's less.
But you're not using the same parking lot, and that was
It's a pretty
our
large parking lot.
It's not that large, it's 125 spaces, so they have about 25 more than what zoning would require.
And how
but,
many spaces in the Paletti lot?
Offhand, I think we're close to 40 with that, just for that one business. So you see where the differences come in, where that was our main concern.
There's 40 parking spots at the
Yes,
Paletti?
they plan to reconfigure the parking lot
Okay.
and do some landscaping there. So I think we were close to 38 or 43. Don't quote me, it's in the packet.
No,
but-
okay, yeah,
But,
thank
so
you.
we were looking at it more as, this is, they came in and said, we have 125 parking spaces to use.
Mm-hmm.
And we said, well, really, you don't. We need to know, what do the tenants have? What do they have for employees? How many seats do they have in the pizza place, for instance? So that was mainly the reason that they reached out to the neighbors to say, how many employees do you have in here? How many seats do you have? When are your busy times?
Right.
They needed to do all that to try to arrive at some set of traffic information for us.
I get it. And do they have a traffic deficiency now? I mean, a parking deficiency now?
I think that anybody will have a parking deficiency if we don't use the appointment-only app. If you,
Okay.
all of the locations more than meet the zoning requirements for retail. Retail, we require one parking space for 200 square feet and one per employee working on the largest shift. But as we know, these aren't normal retail operations. I think that, the traffic will become more minimal as more facilities open, but we've seen in other communities that it gets very busy. So I think that you can't say that, it meets the parking. I mean, it meets the zoning requirements, but time will
understand.
tell if it meets the parking requirements.
But in your view, all of the applicants will have a
Yes.
parking deficiency if we don't utilize appointment only, most likely. I don't want to
They could in the beginning. I think we saw it with Cultivate in Leicester. I mean, nobody could have accounted for all of that. They were one of the first to open. There were only 2 retail locations in the state at that time.
Right, but-
Traffic was horribly tied
Right,
up.
but interesting that you bring it up, because I did clip that article,
Mm-hmm.
and on opening day, they had 1,000 customers.
Right.
But I also inquired at our meeting with the applicants on a regular basis, what did
Yes.
their business model call for?
Right.
And one applicant said 1,000
Right.
a day, and the other applicant said 500. So conceivably, if their numbers, work, and I know everybody has optimism when it comes to
Right.
that, but if it was 1,000 applicants a day, that's basically the same amount of customers that Leicester faced on their opening day every single day in Sturbridge.
Right,
So that's significant. I mean, that.
it is.
Okay, and then my other question is probably better for the police chief, but he had more traffic concerns with Charlton Road
Yes.
than he does with the mobile station, which is actually off of the
Yes.
highway.
That makes sense.
Yes, because it's only
one
one way
way.
in.
Makes sense.
You're,
You can
there's
only
no
go one way.
cross-traffic there. You have to be coming up 131 to enter, and then you'd have to exit there and turn around and come back. You can't cross
go
the
across the street.
median.
The other
It's
was
split
the
there.
4-lane.
The other's the 4-lane with no median to divide it. So yes, he was very concerned with the other. He's very concerned with Route 20 in general.
Right, except, yeah, I mean, it's
Yeah.
a little bit of this and that.
Right.
Route 20 is right off the highway, and it has 2 lanes on both sides.
Right.
20 and 131 are smaller roads, so it's a little bit of this and that, I
Yeah.
guess.
Traffic's always a concern. Okay. Priscilla?
Traffic too, I know we talked about having them do appointment only, but the reality is, as soon as it hits the word gets out that Sturbridge has opened a first retail shop, they're gonna come in without an appointment. I mean, so what I'm trying to say is, the traffic will be there. Okay, so you may have, let's say, 50 cars, and maybe 20 of those cars have an appointment. The other 30 are trying to see if they can get in. So initially, I think you're gonna have impact no matter what.
Right, I agree with you, and we've talked about this with all of the applicants. So with each one of the applicants, we talked about leaving a certain amount of spaces empty. So when they schedule their appointments, say they had 25 spaces, when they scheduled their appointments initially on the app, we've suggested, and some of them have actually offered, that they would leave X number of spaces vacant. They would have 2 people potentially stationed in the parking lot for traffic control and to see, do you have an appointment? Oh, you don't have an appointment. Could you pull over there to one of these spaces? They would then go over to that person, provide them with literature on how to make an appointment. If there's a time slot available that day, they could make an appointment right there on their tablet, and if not, they would send them off with that information of how to make an appointment at a later date. So I totally agree with you. I think that, there will be impacts. I think that's the purpose of the host community agreement, and I also think it's part of the special permit process, but I agree.
Yeah.
And there's probably impacts that we're not thinking of that.
I agree.
you
I
know.
totally agree, and there's 2 spots, which I won't mention, but there's 2 spots that I feel are going to be the most impacted, or the most dangerously impacted, if you will, if you have traffic that's just looking to get in and doesn't have an appointment because, oh, well, I'm going to try it anyway. I'm going to try to see if I can get there. So it's all well and good that we can bring the car to the side, and maybe we can bring 5 cars to the side, but what about the other 25? That's where my concern comes, and
Right.
there's 2 spots that I see that this can really have an impact.
Mhm.
Thanks, Jane.
You're welcome.
Anything else? Yay, thank you. Jeff?
Yes, so the takeaways from this evening, I think, is first, bring back a draft written policy for you all to consider in terms of what, how many and under what conditions you would grant an approval. And then we would go back with all 4 and start crafting or negotiating host community agreements for your review. I think those are the 2 takeaways.
Right, that's what I starred.
How long is a permit good for?
Sorry,
How long is the permit good for? In other
Special
words,
permit.
Special
a special
permit?
permit, yeah.
1 year. They
1
have to
year.
make use within 1 year.
And then the third takeaway is a copy of the Cannabis Control Commission's regulations.
Is those negotiations not in executive session, or?
Yeah.
we have to-
Yeah, we'll do some and then bring you back a document and then see how it fits for you, and then we'll go back.
So the special permit is good for every year, they're reissued?
Oh, no, I'm
That's what
sorry.
I'm asking.
Oh, no, once you make use of the permit, it's valid.
It's valid, period.
Right.
So, let's say we make a decision with 2 applicants, and we're kind of weighing, one of the applicants, we could have gone either to this one or this one. They're both professional, they have a good business plan, and it turns out we're not happy with whatever is going on, the negative impact. I assume there'll be provisions within the host agreement if they violate it to terminate that and give the permit to somebody else. In other words, what is the mechanism to opt out of one applicant, permit holder, if it's not working out and we want to issue the license to somebody else? Let's say it is permit only, let's say it is appointment only, I'll give you a concrete example, and they're clearly violating that. They're letting, many more in that don't have an appointment. That's just one example. There could be other violations. Or they're serving, or they're, on more than one occasion, have given to, a teenager under the age, or whatever. There'll be provisions in what is the process? There's provisions in the host agreement, and then we would be free to terminate that relationship and issue the permit to a different business?
So it depends on the way it's structured. If there's a requirement in the special permit that they use the app, we can proceed as a violation of the special permit, and we could choose to enforce that way by issuing a cease and desist.
Okay.
And that would be then enforced through court proceedings. If there is a provision in the host community agreement that anticipates a violation, or there is a provision in the host community agreement that is being violated, it would also likely be court proceedings to obtain enforcement.
And we could do both. I just want to do whatever protects the town the most, because we don't have relationships, with the exception of HEAL, with any of the applicants at this point.
Correct.
So it's a bit of, we're in a position where we're going to do our best to issue the 2 licenses to the best applicants in terms of Sturbridge's interests, but we could err. And I want to know what the process is to correct that if we've made a mistake.
Sure, so a requirement, for example, for that appointment-only app could be in the host community agreement. It could also be something that appears in the special permit. It could appear in one and not the other. Again, it all depends on the way that the town chooses to structure both the host community agreement and the special permit.
Right, I mean, same with hours of operation.
Right, anything,
There's a
I mean-
violation there. I mean, there's a process. It's
Right. And what is the average, the spectrum in terms of the length of the host agreement? I know you said that I know the impact has to be, it's what?
The community impact fee is limited for a term of 5 years. It is subject to renegotiation. We typically recommend that host community agreements run for the life of the establishment. Some communities have limited their host community agreements to the whole agreement to 5 years with a renegotiation provision, so that the community could come back after 5 years and renegotiate the terms. For example, if there are more impacts or less impacts, to incorporate whatever changes it feels needs to be made into the host community agreement.
And that's not what to me, just off the cuff, that seems like the best course of action. If the impact fee has to be 5 years, why do you advise your clients to not have a 5-year host agreement?
It depends the concerns of the municipality. Some communities don't want to have to come back and reopen the entire host community agreement, and so they run it for the life of the facility that operates in town, and they've made it so that certain provisions are subject to a lesser term with the provision that those will be renegotiated. So we've seen host community agreements, for example, that run for the life of the operation, and within those host community agreements, there is a reopener clause to say if the applicant goes in and opens and executes another host community agreement, we could reopen this host community agreement and renegotiate the terms if there were more beneficial terms offered to that other community. Also, again, for the community impacts that can get renegotiated after the 5 years. You can also do it with the community benefit payment, that the community benefit payment will be a certain payment for a certain amount of terms, and then it gets renegotiated. So the host community agreement itself could run for the life, and then the specific provisions within it could have certain terms subject
So
to
it's up to the
renegotiation.
town if we wanted to open it all up.
It could be structured.
It sounds easy to just open up the whole contract rather than a lot of individual provisions, but thank you.
Okay, thank you. Thank you for coming.
One thing that I would recommend for the board, and we've seen a lot of communities do, is to nominate either a member or a planner or another town official to engage in negotiations with the applicants, because the board cannot meet in executive session to discuss these, in my opinion. And so if you have
We can't.
No, so in my opinion, the board would not be able to meet in an executive session to discuss pending applications.
Okay, so
But
it's
it would
different
be-
than like labor contracts. That's definitely, these have to be in, the negotiations have to be a public meeting.
Labor contracts would be collective bargaining, which.
Right.
Right.
Yeah, so this isn't a collective bargaining agreement.
No, I know, but it's a
Yeah.
negotiation, but that has to be in an open session.
Correct.
Wow.
Okay, so
And
that answers
therefore,
the opposite. You asked, and it was the opposite.
Yeah, so
He asked if you could be
that's
in
why
executive session.
I was
and you
just
said yes.
clarifying because, oh, no, I
Who
didn't.
said yes? Somebody did.
I just wanted to, I just
I
wanted
thought
to.
a
Oh, you
contract,
did.
you-
Somebody did. Me too.
I thought
When you're looking at the economics of the applicants.
I know.
Well, and so that's why we suggest that someone be nominated to go back and forth with the specific details.
Of course.
And then a presentation could be made to the board.
Absolutely. That's like the biggest thing to take away from
Yes,
tonight.
because there isn't an exemption that would allow the board,
You know
in
what I
my
mean?
opinion,
That's
to
like,
discuss this.
I thought that we
It's a
could.
shocker.
Me
Yeah.
too, because
I mean,
everything we negotiate, our TA's contract, that's,
anything, because, I mean, if we're talking a contract with one company in open session, the other company's gonna hear about it.
Very odd.
It's,
Sure, and so you would cite to the specific exemption that allows for collective bargaining. So there's specific exemptions under the open meeting law, for example, litigation and collective bargaining, and that's what allows you to go in to discuss an executive session. Here, there's not a provision in the open meeting law that allows you to negotiate contracts in general contracts in executive session, unless unless one of those triggers are applied.
Now, did the Cannabis Control Commission regulations address this head-on, or is this KP's advice to us, given the fact that the open meeting law doesn't have an exemption? Like, did they address this issue head-on? And-
No, so
okay.
the Cannabis Control Commission has said, as of now, their position may change, but right now, their position has been that they do not have the authority to regulate host community agreements, they do not have the authority to advise on open meeting law, and they will not be regulating host community agreements.
I think that's such a, well,
Yeah,
I think that is a
anyways.
real deficiency in the law, that they haven't said one way or another that negotiations have to be an open session or not.
Well,
It's leaving it up to interpretation and probably a court case
Well,
at
the
some
open
point.
meeting law does have those 8 exceptions, and so the open meeting law still would apply.
Right, but the open meeting law predate, it hasn't caught up. It predates this legislation. So that's why it doesn't address it, because it didn't exist. But anyways, yeah, I think that's the biggest thing that we need as a negotiator, because I agree with our chair. Why,
yeah,
we're talking about, well,
yeah, three's gonna hear what
yeah.
first one we bring up and maybe change their plans, and it gets convoluted that way. I mean, it's, but,
Interesting.
well, thank you. So we shall move. Jeff?
Pick a negotiator.
Oh, did you want it tonight?
You may
Yeah,
as
because
well.
we're going to start.
Oh, okay. I personally will nominate Jeff as our
I
negotiator.
second that one 100%.
Any discussion? All in favor?
Awesome.
No one better.
In my negotiating team.
Yeah.
Yes. Well, thank you, everybody.
Thank you very much.
Enjoy the wet week.
Thank you.
He gets the
Oh, yeah,
civil, he gets the civil,
The grass guy.
academic award. The civics lesson. The civics lesson. I used to drag our son at that age to town meeting, he had to sit in a certain section, and now he can vote, but back then he couldn't.
My ex is a probate family attorney, and she's brought him to court.
Oh, wow.
So fun times.
A fledgling attorney, maybe.
Oh, no.
Probably turn him off.
It turned me off. That's for sure.
No offense, Bob.
My son is 18 years old and is going to his first town meeting tonight, married.
And he's,
Oh, wow.
and he's gonna get to vote, right? Very
Wow.
exciting.
Stay, and I said, yes, you
Take care.
Good deal.
Yeah.
Thank you.
We don't have a motion to adjourn yet, did we?
No, I'm waiting for
I
Priscilla.
I don't think it was on there, but motion to adjourn.
Is there a second? Any discussion? All in favor? Perfect timing. My chauffeur is,
For all of us.
yeah, my chauffeur is going to be here at 20 off.
Oh, well, that works.
Oh, I was just going to ask if you needed a ride.
Oh, no, thanks.
He's injured too.